Hello, everyone. Thanks for joining us today for our 30-minute Saul session. Today marks our third installment of our Saul series, Navigating Legal and Regulatory Challenges Throughout the Life Cycle of a Cannabis Business. Today's topic, we are going to cover labor and employment complexities as they impact cannabis and in the cannabis industry. My name is Ruth Rawls. I'm here with my colleague, Eric Pramschufer, and we're really glad to have you with us. Feel free to pose any questions in the Q&A. One of us will be looking at them as we go through this, and we'll try to get to your questions as they pop up. So with that said, let's begin. As I said, my name is Ruth Rawls. I am a partner at Saul. I'm the chair of our labor and employment group here at the firm. So I deal with all things labor and employment, and more recently than not, things that deal with cannabis and employment law questions. So many of the things that we talk about today are applicable to most employers that are navigating issues with respect to cannabis and in the cannabis space. It's really one of those if not when, it's going to happen at some point. If you're in the cannabis industry, most likely your employees are users of cannabis on a regular basis. And with the proliferation of adult use statutes in states, for employers that are not in the industry, it is not a matter of if, it is a matter of when you're going to be dealing with something with respect to an employee that's using cannabis, either medically or in the adult use context. So as we're going to talk about today, nearly every complexity when it comes to managing labor and employment issues with respect to cannabis really comes from the inescapable fact that if someone is regularly using cannabis, they are always going to test positive, almost always going to test positive for THC in response to a drug test. So I will say it probably 4 or 5 more times, but the bumper sticker for today is presence does not equal impairment when it comes to cannabis. Meaning if you have cannabis in your system and you test positive, that does not necessarily mean someone is impaired. There's no breathalyzer. There is no acute intoxication test for cannabis. So for virtually every employment decision that impacts a business with respect to cannabis, you're going to have to keep that in mind and recognize that a test is not going to tell us if someone is impaired at work. Instead, we're going to have to make decisions about impairment. And that is not new, right? The sky is not falling. We are employers that have been making impairment decisions for a very long time. We're just talking about it in the cannabis space here. So the thing to also keep in mind as we walk through this is employers are not required to make the perfect or quote unquote correct decision with respect to employees, particularly when we're dealing with this issue as well. But rather what we're prohibited from doing as employers is making decisions that could be considered discriminatory. That's where the issue arises in the exposure risk and in the labor and employment space when we're dealing with our employees. So when Eric and I were talking about kind of how we wanted to structure and the things we wanted to cover today, we thought, let's talk about medical cannabis because that's a whole different thing. Then we're going to talk a little bit about drug testing, touching on some of the things I've already raised, and then adult use, because that, again, it's a different animal and it's popping up all over the place. So it's impacting employers everywhere. So with that, I'm just going to ask Eric, can you just kind of start and give us a little bit of a primer on medical cannabis and how it impacts disability discrimination issues and what employers should be on the lookout for?
Yeah, no, absolutely. Thanks, Ruth. Yeah, so when we're talking about medical cannabis, and this has been a trend in litigation for long before kind of the recent trend of adult use that, people have been making theories and claims and bringing lawsuits on the theory that if you take an employment action against me because I am using medical cannabis that's prescribed by my doctor and I'm doing it appropriately and allowed to do it, if you're taking an employment decision against me, that is disability discrimination. Because cannabis is still considered illegal under federal law, the Americans with Disabilities Act, which is our general framework that we, as employment lawyers, we typically look at these, disability issues under the lens of, that statute specifically falls out of the way for the most part. But with that being said, most states, if not all states, have some form of state-specific law prohibiting disability discrimination. Some states even go one step further and expressly provide in their statute that somebody can't be discriminated against because they use medical cannabis, or say that somebody who uses medical cannabis is by definition under the statute considered somebody with a disability. So it's the state-specific disability discrimination laws that a lot of lawsuits have been brought under. Particularly, there's, going to Ruth's point about drug testing, like there is one case that, Ruth and myself and other labor and employment attorneys like always look to, because it's such a kind of classic fact pattern of how difficult these issues are to navigate, but also provides a good framework for being able to put policies in place and kind of understanding how this works in the real world. So this was a case that reached the New Jersey Supreme Court. When was it, Ruth? It was like 3 years ago, I think.
Yes, 3 or 4 years ago, I think.
Yeah, and it's pretty universally held. It was Wild versus, and we call it the Wild decision. Anybody who's interested in a citation, we'd be happy to provide it to you. But basically, the employee worked for a funeral home. One of their duties was to drive. They got into a car accident. They went to the hospital. Did not tell their employer beforehand that they used medical cannabis, but the employer came and told the employee, hey, you got into a workplace accident. Under our policies, under our workers' comp guidelines, you have to take a drug test and you have to take an alcohol test. The employee responded, well, actually, boss, I am a medical cannabis user. Because of that, I'm going to test positive definitively, but I'm not impaired now. And the plaintiff even alleged that he spoke to the ER doctor who saw him, and the ER doctor also verified he wasn't impaired at the time. Boss says, take the drug test. You got to do it. It's the policy. Took the drug test, failed it. Employee was fired, and the employer made this offhand remark, again, according to the allegations from the plaintiff, that we can't handle your cannabis use, right? We can't accommodate that. Under that fact pattern, New Jersey, under the New Jersey law against discrimination, which is a relatively broad statute, but in line with most other disability discrimination statutes, the court found that that fact pattern, the plaintiff stated a claim for disability discrimination. And the important part, again, is that it's not just discrimination against the person because they're a medical cannabis user, it's because of that person's disability. And that there is, at a minimum, an obligation for the employer to kind of have a conversation with the employee about what their uses are, what, if anything, that might prohibit them at work. And here, the employer failed to even engage in that process. Again, the hard part about that case for the employer's perspective is, they followed the process. As I said, workers' comp was clearly involved in this, and they felt that they were doing the appropriate thing that was being told by them. But they could have just made their lives a lot easier by documenting things at the time of the actual accident. As Ruth mentioned, like the test itself is not probative to whether the person was actually impaired. And it would have been a completely different story if the employer made the decision to terminate and said, well, you failed the drug test, and right after the accident we spoke to you and you seemed to be impaired at the time. And that's what, Ruth has worked with a lot of different employers on kind of putting those policies together and walking them through the basic framework of how they work and kind of the nitty-gritty, as well as training and things like that. And Ruth, I'm wondering, what's kind of the first step that you suggest to employers when, either, I guess the first step, both employers being proactive of dealing, with these issues ahead of time, which hopefully most people are, and then also kind of the flip side of an issue came in, maybe there was a workplace accident, maybe don't have the policies in line. Like, is there a different approach in those scenarios, or are you suggesting they follow the same process in each?
Yeah, I mean, I think, that the most important thing kind of understanding this is education, which I think is one of the things you alluded to. And that is making sure that our frontline managers and the folks that are actually interacting with these employees on a regular basis understand the obligations and understand the reality of the situation. And as Eric was saying, and we were talking about, just a drug test alone is not going to do it. So there's got to be more there. So it's talking about what a drug test is, what impairment is, and how do you kind of recognize and marry those two things together. It's very different than alcohol, where you've got a test that can tell you if someone's impaired and you can completely rely on that. So there's a lot of education that has to go on from the top to the bottom, and from the bottom to the top of, we can't just say drug tests, check the box, check this form, and we're good to go. There's more to it than that. So there's got to be some training that goes with it. So really the recommendation and the best practice, not just for cannabis, but definitely for any types of impairment and considering cannabis, is drug testing, which is the scientifically reliable drug test, plus documenting and identifying what we call articulable symptoms of impairment. And that's been around for a while. We all know what that is. Employers have had those tools at their disposal. We just have to think about them a little bit different here. And this process is actually kind of baked into the New Jersey adult use statute, which takes that into account. And I think and I'm going to talk about that in just a second, but just to kind of follow up on the first part of that question that Eric asked, one thing that we also need to be aware of is, in a lot of states that have passed adult use laws, they have eliminated the ability for employers to do pre-employment drug testing. So you should really, really think hard and know what your obligations are in the states you are in, as to whether or not you can actually just do pre-employment drug testing for cannabis. A lot of, like New York is a good example of a state that has said can't do that anymore, with certain exceptions. So kind of talking about like what drug testing is. So New Jersey's statute's a really good example of laying out this drug testing plus observations of impairment in order to take some type of adverse employment action. And the statute starts out by saying, and a lot of the state statutes start out by saying this and using similar language along the lines of, an employee shall not be subject to an adverse action by an employer solely due to the presence of cannabinoid metabolites in the employee's bodily fluid from engaging in conduct permitted under the adult use statute. Now, there's some questions embedded in there. If I have an 18-year-old that tests positive for cannabis, that's a little different, because adult use in New Jersey only applies to people that are 21 and over. So there's some pieces in there to be aware of in terms of how we're dealing with folks and what our employee population consists of. So we can't take an adverse action solely based on that. We have to, but then the statute goes on to define drug testing. It defines it in the way that I think most of us understand it, right? It's some type of laboratory test that confirms the presence of some substance in a bodily fluid. But then it also says, and a physical evaluation in order to determine the employee's state of impairment. So it marries the two together. Now, New Jersey has this interesting thing about who's doing the physical evaluation, and this concept of a workplace impairment recognition expert. We call it a WIRE. We haven't seen that in a lot of states. There's a few that have it and a few that are catching on. But the concept is similar to what Eric was asking about initially, was training our managers to document what is actually impairment. What does that mean? What does it look like? New Jersey has a form that came out with their guidance that says, hey, here are the things to look at. I think Colorado has a form, a couple of other states have it. And most employers have some, like larger employers have some type of form where they're kind of going through and checking the boxes of what it is. However, again, you got to know what the state law is, because some states lay out what articulable symptoms of impairment are. The things that we would think they are: red eyes, slurring your words, things like that. Yep, those are probably okay. New York City really went out on a limb and said, you know what is not a symptom of impairment is smell. So if you smell like cannabis, that's not enough for an employer to say you have a positive drug test and I think that you're impaired. There's got to be more. So I always throw that out there because I find that to be interesting in their guidance, and they specifically laid that out. So knowing and understanding what the states permit you to do and not do is very important. Another component, just to kind of touch on some of the things that Eric said, are when we're talking about workers' comp, that raises insurance issues, that raises what you have to do and with respect to drug testing. And it's going to be, what you may have to do for your workers' comp policy and what you may have to do and document to take an adverse employment action against an employee if you suspect they are impaired may not be the same thing. So just understanding kind of those differences and nuances is important. And then, the thing I think you'll hear every labor and employment lawyer say when you talk to about any employment issue is document, 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 right? Let's have documents in place, forms to fill out, something that's like laying out something contemporaneous with the decision that we're making, so that if something happens, we're not racking our brains to figure it out, or have somebody say, well, I think, they were like maybe doing that. Like, it's written down and we have it and we're maintaining those files. Right. So that's a little bit about medical. That's a little bit about drug testing. I think where the rubber hits the road for most employers right now is adult use cannabis, and kind of what does that mean and what does that mean for employers? So Eric, can you just talk a little bit about kind of how that changes the playing field a bit?
Yeah, and the adult use cannabis industry, as it relates to different states, it depends on the state law, and each state's a little bit different. I primarily practice in New York, and I think one of the things that New York's done that's frankly helpful to New York employers, and I think is helpful to employers beyond New York, because it's a good guide of frankly an agency that did their homework and thought through these things, is what you can do. Ruth mentioned with respect to pre-employment drug tests, right? So New York has issued as a matter of guidance that you cannot do any kind of pre-employment drug tests for cannabis. And the purpose of that, to the point that we keep reiterating, is that if somebody uses cannabis legally for medical purposes or for personal purposes, they're always going to test positive, right? And New York has a very old law that goes back to this lobbying from the cigarette industry of saying you can't basically you cannot penalize somebody for what they do outside of work. It says smoking tobacco, using alcohol, and New York just wrote into that law utilizing cannabis in a legal way under the adult use statute. So with that law in mind, employers are prohibited from taking any, adverse action against employees because of what they do outside of work. No different than employers have already been prohibited from the same thing with respect to cigarettes and alcohol and how you vote and all the other things that have already been protected that are outside of work. It's no different. The difference comes down to the testing, right? And again, recognizing that the testing can only go so far, both pre-employment, then also during employment. As Ruth mentioned, to the extent there's an accident or there's another reason to test somebody, right? You need, the New York law is clear that you need both a positive drug test and the articulable symptoms of impairment, as the New York agency has defined those. And that's the primary change. And I think I'm dealing with this now with some folks in Maryland, right, where the Maryland law is a bit more unclear and we're starting to see the regulations come out. How do I treat employees who, test, maybe Maryland doesn't have a statute or regulation saying you cannot screen employees for cannabis, and it might be an employer who wants to screen for drug panels might have a requirement to screen on drug tests. And what do I do with the recreational employees? And the answer generally is, unless there's a federal agency or law that prohibits you from hiring them, you shouldn't be treating them any different for what they do outside of work, so long as it doesn't actually influence them inside of work. Ruth's mentioned it's a little different from alcohol, in a lot of the testing respects, but in this context, I treat it and I tell people to treat it the same thing as alcohol. When most employers would not decline an applicant for employment because they, drink a glass of wine after work. It's no different for cannabis. Again, the important part is the testing and recognizing, when somebody might be impaired. But with that being said, the one thing, there's very few constants and black letter answers in any of this. I think the one that exists across all states, unless Ruth corrects me, is, there's no obligation of an employer to say you are permitted to consume cannabis either, on working time or on company premises, or to possess cannabis, right? And I think that that's something that's particularly important for the cannabis industry, particularly the retail cannabis industry, right? You would be concerned, like any other retail industry, you do have your own policies against employee theft, and you're concerned about employees stealing from each other. And one way to address that is, not permitting people to bring their own, personal supplies to work. And there's absolutely no requirement, even in the most liberal state that allows adult use cannabis, to allow employees to do that. So I think that's where the biggest trend is. I mean, Ruth, you touched upon one point with drug testing, and we've talked about it. And, the states where there might not be an explicit, where adult use might be permitted, but there's not an explicit requirement saying you cannot drug test pre-employment. Do you think there's risk for employers who do still drug test, even if there's not a law saying you can't?
Yeah, I mean, I think it's interesting because the statutes take kind of like, I put them in three buckets. There are statutes that say you can discriminate, which are few and far between right now. So ones that say you can't, and then the ones that say nothing at all. Just leave you to kind of read the tea leaves on what to do. I don't know that there's a good practice, but what I would say is that there is a significant trend to employers dropping cannabis from their pre-employment drug screens. We've seen some employers just make big splashy announcements about it. Sometimes that's after a couple of lawsuits have been filed. And then, others, they just drop it and don't say anything about it. So it's kind of just disappearing. So I think, it in some instances, it comes down to a cost benefit analysis, right? Like if this isn't really telling me anything that's helpful, and quite frankly, the public policy and the trend towards the judgment associated with being a cannabis user it's drastically changing. I mean, the pendulum is completely swinging the opposite way. So I think there's definitely an effort by employers to kind of catch up with that. Or they're also not able to fill jobs because they can't find enough applicants that can pass a drug screen, particularly because of the cannabis issue. So those things are kind of falling to the wayside. I do want to just emphasize two points that come up that we haven't touched on yet. And we've said a lot about unless there's an exception. So what does that mean when we're talking about these state statutes? Usually there is some type of safety sensitive position exception in some of the laws. New York has a lot of them. New Jersey has none. But is it a safety sensitive position that allows you to do some type of testing that you wouldn't be able to do otherwise? And then the question I always get when I talk about this is somebody goes, what about the Drug-Free Workplace Act? Doesn't that mean that I have to, I can't, I have to test people and I can't have people working if they're using cannabis because it's federally illegal? The answer is no. The District of Connecticut had a case with a federal contractor, the Knopfsinger decision, where that federal contractor actually tested positive for cannabis. They were terminated, and it came down to a summary judgment decision. And what the court said in that case was, look, the Drug-Free Workplace Act does not mean that you have to drug test people. It also doesn't mean, to Eric's point, that you're policing what people are doing in their home and their private time away from work, off work activity. What it means is you don't have to allow people to be impaired at work, and you have policies and procedures to stop that from happening. So again, to the point that Eric raised, there's no law that I'm aware of in the cannabis space that requires an employer to permit employees to be impaired while they're at work under cannabis, to use or ingest cannabis or cannabis products while they're at work, or to bring cannabis products on site. Almost all of the laws are universal in that prescription. So, you can have a drug-free workplace policy and it's still enforceable. But what you can't do is apply, make it much broader than what courts have said it applies to. And that's really kind of an interesting factor. Even when you're dealing with federal employees and federal contractors, same thing. And then I also want to address the other exception that we see is unless there's a federal regulation that requires it. So what does that mean? The easiest example of that is a CDL license holder. If someone has a commercial driver's license and is driving a truck, underneath Department of Transportation rules, there are specific drug testing requirements. Cannabis is on that list, and there's no ifs, ands, or buts about it. That's the federal law on point that says you have to do this, and it's an exception to most of the state statutes because we still have this federal state dichotomy where we've got a substance, even though it's being rescheduled. There's a big difference. It's being rescheduled to Schedule 3 versus Schedule 1, but it's not being descheduled. So you still have this federal state kind of dichotomy that exists when we're talking about cannabis in the workplace. So I think just to kind of summarize what we've talked about today, it's important to understand, one, what state you're in and what your obligations in that state are. With respect to drug testing and what you can and can't do with respect to impairment and how you need to document that, have policies and practices in place. And a policy is only as good as the piece of paper it's written on. So if you have a really great policy and you put it on somebody's desk, that's not going to get you much of anywhere. You have to train the folks that are interacting with your employees on a regular basis how to use that policy, how to document what they want to do so that you're not on the back end of one of these lawsuits alleging discrimination, which Eric raised, or possibly violations under the state statutes that are in play. I think that covers most of what we wanted to talk about today. So nothing more fun than talking about drug testing at 4:20 in the afternoon, and employer and employee obligations and responsibilities. I wanted to say thank you, folks, for joining us today. We hope you learned a little bit, if not a lot, about the space. And I really hope that you all join additional Saul Sessions for issues that are impacting the cannabis industry. Thank you.